Mr. Goldberg. All right, counsel, we have a number of legal issues to discuss before we start with the jury. I have the jury upstairs in the lounge, since we'll probably be at this for a while. What I have scheduled is the first morning session to approximately 10:30 for motions this morning, but we have a number of matters we need to take up. Counsel, what's your pleasure as far as which motions to address first? Ms. Lewis?
Your Honor, I think one of the first things maybe scheduled for today was a hearing with regard to collateral impeachment witnesses of Detective Furman. May we go ahead and handle that one?
All right. Good morning, counsel.
Good morning. Your Honor, this is a motion which was brought because of the defense desire to use additional extrinsic evidence to collaterally impeach Detective Furman's credibility. As the court is well aware, you have wide discretion in the use of extrinsic evidence for collateral impeachment and in collateral impeachment as a whole. And it's an area where many courts do exercise their discretion in precluding substantial evidence of collateral impeachment, because it does tend, no matter what the issue and what the trial, to take things off of track in terms of the probative evidence in the case. Now, in this case, early on, the court heard the offers of proof from the defense with regard to a variety of potential witnesses with regard to Detective Mark Furman. And the court ruled, if I recall, that because Kathleen Bell had indicated that the racial statement she attributes to Detective Furman talked about a black and white couple together, and also implied the manufacture of evidence, that the court felt because...
No, it directly implicated the manufacturing of probable cause.
All right, exactly. And I believe that's what the court felt was most probative about that particular offer of proof from the defense, if I'm not mistaken. So that's why the court used its discretion in terms of allowing the defense to use that collateral impeachment, extrinsic evidence of collateral impeachment. And later, after that, the defense came up with Andrea Cheri, who corroborates in some ways, though she actually contrasts with Kathleen Bell on an important point. But from the defense way of thinking, apparently she corroborates Kathleen Bell, and she as well indicates or alleges that the detective used a racial slur with regard to black and white couples being together. So for the combination reason that she indicated black and white couples and that she tended to corroborate in the defense eyes, at least Kathleen Bell, the court allowed cross-examination with regard to her statement as well. Now, in this case, early on when the court made those rulings, the defense had impliedly, if not openly, asserted over and over and over that they would be producing evidence that Detective Furman had either the opportunity to plant the Rockingham glove or actual evidence that he did so. And now here we are through the people's case, most of the way I understand, through the defense case, and they still have no substantial evidence of any police conspiracy. They have no evidence whatsoever that Mark Furman had any opportunity to plant evidence, that he actually did plant any evidence, and I'm sure the court appreciates the distinction when you look at the Hall type of cases. But I'm not even drawing that analogy today, Your Honor, with regard to Hall. I'm asking the court to look purely at the probative value of extrinsic evidence to impeach Detective Furman, given the lack of any evidence in this case linking him to actually doing anything wrong. That makes the probative value of him being a racist almost nil, because even if the defense were to successfully convince the court or anyone else that Detective Furman made these racial slurs and is a racist, that does not show any kind of a link to him actually have planting the Rockingham glove. So this wish on the defense part has just not come true. They have not been able to come up with any evidence that links them to that. Consequently, the evidence showing that he's a racist does nothing in terms of proving their case. On the other hand, because of the inflammatory nature of the remarks at issue, especially in front of this predominantly African-American jury, it does have a substantially undue prejudicial impact on the people. It is something that is abhorrent to hear, and the jury is going to be hearing it already in the form of Kathleen Bell and another racist statement in the form of Andrea Cheri's testimony. So the court has, I believe, generously allowed the defense, and based on good reasons that Your Honor indicated, but has generously allowed the defense the use of these two witnesses that go to this collateral impeachment issue. That is, when you consider the detective's credibility, it's just not as important as it may have once appeared. we have not only the discovery of the glove at Rockingham, but other overwhelming evidence of guilt in this case. The DNA evidence at Bundy, the size and make of the footprints, the shoe prints rather, left at the Bundy scene, the trace and fiber evidence, the lie to Alan Park that the defendant said that he was sleeping when Alan Park had just seen him enter the residence. There is a lot of evidence in this case. This case does not hinge for one moment on the credibility of Detective Furman.
But do you think the defendant owes an explanation to a limousine driver where he's been?
I don't know if he does or not, Your Honor, but the point being, he didn't have to say anything. If that were the case, if he owed no explanation, he didn't have to say anything. He certainly didn't have to say, I've been sleeping. The point is that he did say that and that it was a lie. So why did he make a point of making a lie to a limousine driver when you're right, he didn't owe him any explanation whatsoever. He simply volunteered that lie. And I would say as an alibi of sorts, though it changed over time. And as the trial got going through opening statement into chipping at golf clubs and so forth. Now, in addition, Your Honor, with regard to these recently acquired witnesses from the defense, this court has heard numerous motions for months precipitated by the defense Pitchess motion last fall about alleged racial slurs attributed to Detective Furman. All of that has been broadcast repeatedly to the media. Detective Furman's potential or alleged racial animosity has been an issue before the whole public for many, many months. And in addition, when Mr. Bailey cross-examined Detective Furman, that again brought it to the forefront of this trial. So for the defense to now have recently acquired witnesses, recently discovered witnesses, renders their credibility highly suspect, these people who apparently have only recently come forward. In addition, to the best of my knowledge, and perhaps we can be enlightened since the discovery on these witnesses is very rough and inadequate to really know what time period they're talking about, it's my understanding from other sources that these witnesses alleged over here of statements by Detective Furman went back to the mid-1980s, possibly 87, 88. Perhaps the court can ask for a detailed offer of proof in that regard. But the remoteness of those statements, in addition to there being additional witnesses for collateral impeachment, on the detective's credibility, when his credibility is really not that important now at this stage of the trial, all of that militates in favor of the court exercising the wide discretion that it has and excluding those witnesses. And, Your Honor, since I want to save a little bit of time in rebuttal, I think I will submit with that for this part of the argument.
Mr. Uelmen. Good morning, sir.
I think much of the argument with respect to this motion really misses the point. The defense is less interested in proving that Detective Furman is a racist than we are in proving that Detective Furman is a liar. When the glorious moment finally comes when Your Honor instructs the jury and sends them out to deliberate, I'm confident that one of the instructions you will give, and the reason I'm confident is because both sides will be requesting this instruction. The prosecution already has, and we certainly will.
I just smile at your thought that might be a glorious moment.
The instruction I'm referring to is CalJIC 2.21.2, which will tell the jury that a witness who is willfully false in one material part of his testimony is to be distrusted in others. You may reject the whole testimony of a witness who willfully has testified falsely as to a material point, unless from all of the evidence you believe the probability of truth favors his testimony in other particulars. Now, Your Honor can certainly anticipate that we will argue that instruction with respect to the testimony of Detective Furman, because in that testimony, number one, he flatly denied the Kathleen Bell incident and set up really a test of whether we're going to believe his testimony or believe the testimony of Kathleen Bell. And then he went on in the examination by Mr. Bailey to testify as follows. And you say under oath that you have not addressed any black person as a nigger or spoken about black people as niggers in the past 10 years, Detective Furman? Furman, that's what I'm saying, sir. Question, so that anyone who comes to this court and quotes you as using that word in dealing with African Americans would be a liar, would they not, Detective Furman? Answer, yes, they would. Question, all of them correct? Answer, all of them. Now, this testimony, quite simply, dug a hole for the prosecution, a very deep hole. And over that hole is a headstone that reads, falsus in unum, falsus in omnibus. And that's precisely what CalJIC 2.21.2 is going to tell the jury. Now, we propose to present not only the testimony of Kathleen Bell and Andrea Terry to establish that the conversation alluded to about interracial couples did take place, but we will also present the testimony of Carol Hannock and Natalie Singer. Ms. Hannock, the evidence will show, dated Detective Furman's partner, Tom Vetrano, in 1987, practically contemporaneous with the Kathleen Bell incident. She lived in an apartment in West L.A., and on several occasions, when Mr. Vetrano came to that apartment to pick up Ms. Hannock, he was accompanied by Detective Furman. And in conversations that took place at that time, Mr. Furman frequently used racial epithets, including the word nigger, and expressed great racial animosity in the presence of Ms. Hannock and also in the presence of Ms. Hannock's roommate, Natalie Singer, who will testify that she was present on these occasions, that she heard these epithets, and that she was so offended by them that finally she refused to let Mr. Furman come into the apartment anymore. And finally, we will not be calling Maximo Cardoba at this time, but we do propose to call Roderick Hodge, a gentleman who was arrested by Detective Furman on several occasions in the period 1986 to 1987, again contemporaneous with the Kathleen Bell incident. He will testify that his father is African American, his mother is Caucasian, that this fact was apparently known to Detective Furman, that Detective Furman had arrested him on several occasions, and on one of these occasions, in January of 1987, after arresting Mr. Hodge for a drug offense, he turned to him in the back seat of a police cruiser and said, "I told you we'd get you, nigger." And then in a subsequent strip search of Mr. Hodge and several other African Americans who were arrested with him, he had them bend over in the course of a strip search and said, "You guys look all alike to me." Now, the significance of this evidence is not simply that it shows that Detective Furman is a racist. This evidence shows that Detective Furman is a liar. And the importance of these witnesses is that they all corroborate each other. We haven't heard any concession from the prosecution that they are ready to concede the credibility of any of these witnesses. I think we can anticipate that these witnesses will be attacked. In fact, they already have. Detective Furman has already called them liars. He has already contested the testimony of Kathleen Bell. So we cannot be deprived now of the opportunity to present evidence to persuade the jury that in fact Detective Furman was lying when he testified, and that lie should lead the jury to distrust all of his testimony. Your Honor, of course, already ruled on the issue of whether this issue was material, and I believe Your Honor correctly ruled that the issue of bias is not a collateral issue. The question of whether it's collateral really goes to its cross-examination just as much as the use of extrinsic evidence. If the cross-examination of bias as to bias is proper, then extrinsic evidence is proper when the testimony proves to be false. The only real question being raised about this evidence is the appeal to Your Honor's discretion under 352 to exclude it as somehow cumulative. And here I think you have to put this in the context of a 7-month trial, 6 months of which was devoted to the prosecution case. We are now getting to the heart of the defense case, and to exclude this evidence as cumulative would simply be cutting corners by cutting the heart out of the defense case. There is no question but that a central issue in this trial is the credibility of Detective Furman. And that credibility does not come into question just in the context of whether he planted a glove or not. In our original papers, we pointed out 11 different aspects of Detective Furman's testimony that we are questioning and that we want the jury to question. And that cuts across the entire initial investigation of this case, from the discovery of a blood spot on the Bronco to the alleged discovery of the glove and the circumstances of the discovery of that glove. There are many aspects of his testimony that are of crucial significance to this case, so that the credibility of this detective is unquestionably a central issue in this case. We're less interested, I again say, in proving that he is a racist as we are in proving that he is a liar. And these 5 witnesses corroborating each other, we believe will establish at least a reasonable doubt in the mind of this jury as to whether any of the testimony presented by Detective Furman should be believed.
Mr. Uelmen, specifically the offer of proof by the defense with regards to these witnesses, these 3 additional witnesses, is pretty sketchy at this point. I mean, you've said in generalities, but specifically, what is it that they're going to say?
Well, if Your Honor wants a more detailed outline of the offer of proof, we can certainly provide that. But essentially, what they're going to say is that at approximately the same time that the Kathleen Bell
So I don't
incident.
want approximately, I want specifically. What did they say that Detective Furman said?
That he frequently referred to black people as niggers, that he expressed great racial animosity toward black people. And, you know, I can, if you want, we can offer quotations, but at this point, that's all I'm prepared to indicate. There is no question but that these witnesses will contradict his testimony that he did not use that racial epithet in the past 10 years. And that testimony was quite calculated. Detective Furman attempted to present himself to this jury as a choir boy. And he knew what he was doing. He knew what he was saying when he said this, and he set it up. I mean, he dug the hole. So there's no question but that these witnesses will directly contradict that testimony and show that Detective Furman's testimony in that material respect was false. And on that basis, the jury can reject his entire testimony.
All right. Thank you, Counsel. Any brief response?
Yes, Your Honor. Mr. Uelmen has just confirmed what I indicated to the court, and that is that these witnesses' testimony relates to remote in time incidents, if there's any truth to the incidents whatsoever. He indicated Carol Hannock in 1987. I did not hear an offer of proof with regard to Natalie Singer. Maybe I just didn't hear it, but I believe that she is also at the same time as Carol Hannock in 1987, because my information is that she was Carol Hannock's roommate and may have been present on one or more occasions. So that they are remote in time, and that certainly decreases their probative value. And the fact that Mr. Uelmen is unable to say with any greater specificity what those witnesses would say is also demonstrative of how little their offer of proof amounts to with regard to those witnesses. In addition, I want to remind the court that I did submit in camera ex parte under 1054.7 of the Penal Code some information with regard to Roderick Hodge. Defense counsel has indicated that the arrest they're talking about was in January 1987, and I'd ask the court to consider that information, which is impeachment and not discoverable to the defense, in conjunction with the probative value of Mr. Hodge's testimony, because it seems to demonstrate that he's clearly not telling the truth in terms of the offer of proof given the defense. Mr. Uelmen points to the jury instruction that talks about where a witness is false in a material part of his testimony. And with all due respect to people of color everywhere, I submit that whether or not he used the N-word at some point in the remote past is not a material part of his testimony. Whether he discovered the glove at Rockingham is material. Whether he saw blood inside the Bronco is material. But on this collateral impeachment issue, that is not what the law considers material testimony. It doesn't surprise me, Your Honor, that the defense is electing not to call Maximo Cordova, considering his own self-impeaching testimony, to having talked about remembering these so-called statements that he remembered having dreamt about them the night before. At any rate, Your Honor, I do go back to my initial point, and that is that the court has allowed, and we're not asking the court to reconsider. We're not coming back here whining about Kathleen Bell or Andrea Cheri. The court has already allowed and ruled that they may testify, and they are witnesses that do go to extrinsic collateral impeachment, extrinsic evidence of collateral impeachment of Detective Furman. That is more than I believe, with all respect, Your Honor, that the defense should be allowed to do in this case. The court has generally allowed them to do that, and that is more than enough. We don't need to get sidetracked into a miniature sideshow and miniature trial on the credibility of Detective Furman in terms of whether or not he ever used the N-word. That's prejudicial, it's inflammatory, and it is unduly prejudicial to the prosecution's case. So I think the defense should be precluded. I would ask the court, and that's what the motion is for the court, to preclude these additional parade of additional witnesses to go to this one limited, narrow issue for which they already have 2 witnesses to testify.
All right, thank you, counsel. Counsel, I think that the presentation of this particular issue at this particular time is premature for this reason. The court had ruled that the testimony from Kathleen Bell and from Andrea Cheri was admissible, both for the purpose of demonstrating racial animus and the proclivity to combine that characteristic with the willingness to manufacture probable cause. I found that specifically relevant to the facts and circumstances of this case. After I see how that evidence is presented, and if there's any need for any additional information on that particular issue, then I'll reconsider it. At this time, however, I think the presentation, the offer of proof, is premature. It does strike me immediately as being cumulative, but I think I can only make that determination after I have seen Kathleen Bell and Andrea Cheri testify. So I will take this matter under submission until I hear the testimony of those 2 witnesses. And I take it Mr. Cordoba's off the witness list at this time.
He's not on our short list. We've not given his name somewhere. I think that I don't understand at this point.
All right. Next matter.
Morning, Your Honor. We next have the matters relating to Michelle Kessler's testimony and also the news leak. I don't know whether the court wants to handle those as 2 separate, distinct issues that do relate in a way.
I see one precedes the other. I think what we determine from the Newsleak issue then determines the broadness of the inquiry regarding Michelle Kessler. In our informal discussions yesterday, at sidebar at the conclusion of the day and discussing the matter with counsel, Michelle Kessler, as the then acting head of the laboratory, now the head of the laboratory, can testify to several things that are relevant to this case: the procedures in the lab, who's responsible for what, how their documents are kept. She also conducted the inventory of the evidence that was conducted during the preliminary hearing, and she did in fact examine the socks during that inventory, and I think the defense wants to point out that she saw no readily apparent blood on the socks. So I mean, I can see that there are normal reasons why her testimony would be relevant in this case. The other issue, though, the information about news leaks broadens that inquiry significantly. So I think we need to explore that avenue first. And Mr. Goldberg, do you concede that she is subject to being called as a witness as to the standard issues?
Well, the phrase standard issues is fairly all-encompassing. And I believe that what the defense really wants to do, or might want to do as a fallback position, is call her for the standard issues and then impeach her. And I don't think that is proper. And I'd like to address that at some more length when we actually get to the question of Michelle Kessler's testimony. But perhaps, as the court is suggesting, you could address the issue of the news leaks first.
I think the news leaks is really what determines the scope of what we're going to do.
Thank you. I'd like to start then, Your Honor, by discussing the lack of relevancy of the news leak issue. We did file a supplemental points and authorities on this. I don't know whether the court had an opportunity to read that. That was filed at
Yes.
4:30.
I've got it.
And after talking about the issue of relevancy, which seems like it is a threshold issue, obviously, if the court were to get past that, and we are not suggesting the court ever will, then there is an issue as to the mechanics of how you would go about proving this through admissible evidence. And we have suggested in our points and authorities that that can't be done because there is no legally admissible evidence to prove what it is that the defense seeks to prove here. So starting out with the issue of irrelevancy, we'd first point out, as we did in our points and authorities, that speculative inferences that are derived from evidence cannot be deemed to be relevant to establish the speculatively inferred fact. And that was a quote that came from the case of People versus Babbitt. We suggest that this is a classic case where what it is that the defense is offering is not evidence, but merely a speculative inference that they will be asking the jury to draw from the question of the news leak. Now, in order to get to the speculative inference, that is that the evidence on the socks were planted from the news leak, there is a chain of illogic that the defense must go through, and I tried to break it down into three components that would logically be involved in that chain. The first chain is that the defense would logically have to show or prove, either directly or circumstantially, that there was in fact a news leak stating DNA results. And the reason why we say that this first part of this chain of logic has not been established or cannot be established is that what we have is a situation where on September the 18th, as the court will recall, Gregory Matheson did a PGM subtype test on the socks and found that the PGM subtype was consistent with the victim, Nicole Brown. As the court also knows, very often the serologists refer to these tests involving blood proteins as genetic markers. So we have a situation where there was a test that was being done for genetic markers that found blood that was consistent with the victims on the 18th. The so-called leak was on the 21st. So we don't know, for example, Your Honor, whether what we have is a situation where the news media received information and misinterpreted that information and reported this genetic marker test as being a DNA type test. We don't know specifically what, if anything, was said. And just to give a little bit of an illustration on that, Your Honor, there was an incident quite recently, I don't know whether the court is familiar with it, where some of the detectives in this case were talking and joking out on the courthouse steps with some of the T-shirt vendors, as they frequently do. And one of the newspaper reporters or television reporters, I won't name the agency, asked who these people were, and in what the detectives felt was an obviously joking manner, said that these were 4 surprise prosecution witnesses that we were going to put on at the tail end of our case. The news reporter promptly scurried off, and this was shortly thereafter reported in the media that we had these 4 surprise witnesses, and reporters were scurrying all over the building trying to find out who they were. This was a situation where on its face anyone should have known that that is not a reasonable possibility, that we have discovery laws, we have to disclose people. You don't suddenly just march 4 people into court and put on surprise witnesses. Clearly something that any reasonable person would have seen as being a offhanded comment, a joke. We have seen instances like this over and over and over again, where the news media has completely mischaracterized or outright misstated what happened in court or what happened outside of court. So I do not believe that there's any reason to conclude that they did not do so in this particular case. Also, as the court ruled at the time that this came up back in September, and these were Your Honor's words, let's not even dignify it as a news leak. It is a fabrication, end quote. Your Honor also found the conduct of the news media outrageous and irresponsible. So how are we supposed to infer, based upon the rulings that the court has already made?
And that comment was made in the context of pre-jury selection, and at a time where obviously the court has to be concerned with the defendant's right to select a jury and have a fair trial.
And Your Honor, I think also commented at that same exact time that this also might prejudice the people's right to a fair trial to the extent that it was releasing information that might not necessarily prove to be correct. But the point is, Your Honor, how are we supposed to conclude in a environment where all of us agree, the court, the prosecution, the defense, that stories have been repeatedly put out over the airwaves and in the print media that are incorrect and even irresponsible at times? How are we supposed to trust at face value this story as having accurately stated what was supposedly heard from this source, if indeed there was a source? And this is particularly a problem where we won't be able to cross-examine the person from the news media as to who the source was, what specifically they said, because there is a privilege that attaches. And we can't possibly, therefore, ever explore or undermine this kind of testimony. I don't even know how it could be presented in light of that privilege. The next speculative inference in this chain of illogic, Your Honor.
All right, well, let me ask you this, though. Don't we have to then first determine by summoning in the person who originated this report in the commercial news media and a demand from that person production of the source of that information? Don't we have to do that first? And perhaps in this situation, that person will agree to divulge the source, and then if not, we'll have to conduct a contempt hearing.
Well, there's also a privilege, as the court is aware, that applies to protect unpublished information as well as sources. And we've already been told, I believe, it's already been represented to this court, that that privilege would be invoked here, which is another issue that we also addressed in the brief, Your Honor. But I do agree with the underlying premise of the court's question, which is that before this information could be put before the jury, we would have to have some evidence in an admissible form that the proponent of the evidence, the defense, could put forward to indicate that there was a source for this information, and specifically what the source said. But I go even one step further than the court has just suggested, and that is that in addition to that, they would also have to indicate that that source was an individual from SID in order to make the evidence probative on the issue of evidence planting. And if all they are going to say is that we have a source, that part of the relevancy inquiry is not addressed, because the source could have been, if we're looking at all of the potential candidates for suspicion, SID. It also could have been the police. It also conceivably could have been the Department of Justice. It could have been the DA's office, or it could have been the defense. All of those are possibilities. And there really isn't any evidence that points to any one of those 5 candidates more than the other, if all we have is information that there was a source. The defense said in their moving papers, well, the source said, or the news media said this was a source that was familiar with the investigation. But that does not exclude any one of those 5 candidates that I just mentioned. all of those 5 candidates would fall within the rubric of people who are familiar with the investigation. Or to add a 6th candidate on, Your Honor, it could be an eavesdropper or interloper who intercepted information from any one of those 5 sources. So it also could have been an unintentional disclosure. The third problem in this chain of logic that I've been addressing, Your Honor, on the issue of relevancy is that even if we could assume that there was a leak, and even if we could, in effect, in addition to that, assume that the leak came from SID, is that leak, that assumed leak, probative on the issue of evidence planting, the issue that it's being offered to prove? And I suggest that it is not very clearly. I'd point out, Your Honor, that if we knew that there was evidence on the socks, which we did on August the 4th, significantly before Greg Matheson's PGM subtype and before the news leak. We knew that through the presumptive testing that was performed on that date. There are 7 permutations of whose blood could be on the sock. It could be the blood of Nicole Brown and the defendant, Nicole Brown and Ronald Goldman, Nicole Brown, Ronald Goldman and the defendant, Ronald Goldman, or the defendant and Ronald Goldman. Those are the only 7 possibilities. So simply by guessing, once we know that there's blood on the socks, if we simply guess it's Nicole Brown's blood, we have 4 permutations that include that as one of the possibilities, or a 57% chance of being right.
Refresh my recollection as to what the news report said back in September.
The news report said that blood was found on the sock and that it was reported to be that of Nicole Brown. It didn't say...
By DNA typing.
But by DNA testing. Well, I think one report was that it was the victims, and I believe that there was a subsequent report saying it was Nicole Brown, as I recall. I just listened to it the other night. There were 2 reports. There was one on the 21st and one on the 22nd.
One on the 21st when the claim was made, and on the 22nd when it was reaffirmed.
Yeah.
All right.
But, well, they also said that it was, I'll get to that. They said it was PGM, and, excuse me, they said that it was RFLP and PCR testing. But the point is, Your Honor, is that just by guesswork, if the source said it's Nicole Brown's blood, they have a 57% chance of being correct.
I don't recollect that the 21st or the 22nd that Nicole Brown's name came up specifically.
I thought they had said that, but if they didn't say it and they said that it was the victim's blood, just generically, then there are
Do we have that
6
video?
out of 7. Then they have a 6 out of 7 chance of being right.
Do we have that videotape available?
Yes, I have it upstairs. But the point is, Your Honor, is if they simply said the victim's blood, which is I think what they said on the 21st, then I think there's a 6 out of 7% chance of being right. And probably greater, because it would be a reasonable inference that because there was a lot of victim's blood at the scene.
Let me look at it again, because whether they say have specifics as to whose blood is there, that's an important issue.
Yeah, but
Right.
I would submit, Your Honor, that if they had said it's
No,
Nicole...
I understand the permutations. I
Yeah.
understand what the possibilities
Okay,
are.
but had they said it's Nicole Brown's blood and the defendant's blood, then at least the argument that this was someone with inside information would be slightly stronger than if they simply said it was the victim's blood.
Before we get too far away from this point, Mr. Douglas, do you have that available?
While we're waiting does the court want me to continue, or does the court want me to?
Let me just satisfy my curiosity and refresh my recollection as to what this said, because I think that has the specifics of what is said is important for the rest of the inquiry, I think.
inventory list of the 234 items confiscated from the Simpson estate, the socks are number 13. The list reveals they were found in Simpson's bedroom. Sources say the men's socks, said to be O.J. Simpson's, which had several blood drops, were sent by prosecutors to Selmark Lab in Maryland for DNA testing. And now that testing is complete. Sources have confirmed results from RFLP testing, the most definitive type of DNA test, reveal that the blood on Simpson's socks is a genetic match with Nicole Brown Simpson's blood. The question, how did Nicole Brown Simpson's blood get there? That's a question that may be very difficult for O.J. Simpson to explain.
Thank you for rerunning that tape. I also see on the tape, though, that they, and I should have picked up on this earlier, that they said that the socks were sent to Selmark, and in fact they were sent to the Department of Justice. So that's another inaccuracy in the news report, which again leads us away from the conclusion that the person had inside information. Obviously, they said that it had already been sent for DNA testing, and that wasn't true because it wasn't sent out until the 26th of September, which was a number of days after the leak. So that's another misstatement. And then in the retraction story, this was after Ms. Clark was in court and said to the court, no, the items have, excuse me, she said, no, the socks have not yet been sent out for DNA testing. Following that statement in court, the news media reported, well, that's true, the socks haven't been sent out. However, a cutting from the sock was sent out, and that's also incorrect because we had neither sent out cuttings from the sock nor had we sent out the sock itself as of that date. So all around, the report that was issued by the news media is incorrect. The only thing that they state that can be characterized as being correct is that Nicole Brown's blood was on the sock. However, that's only a partially correct statement because the defendant's blood was on the socks as well. So there's nothing about the report itself which leads us to the conclusion that it came from someone with inside knowledge or someone other than a crackpot. And there is every indication in the report itself that it did not because of the numerous inaccuracies of the report. Now, getting to this third relevancy issue, and that is, I think, probably the key one here, is even if we could get over the other two relevancy hurdles, why would a leak be relevant on the issue of evidence planting? The defense has simply assumed that it would be relevant without articulating why it would be. And in trying to articulate that a little bit, I'd like the court to envision two scenarios. Under scenario number one, we'll call this evidence planting scenario number one. What happens is the socks themselves are planted at the defendant's home. But apparently, according to this scenario, when the socks were seen on the 24th of June and the 29th of June, there's no blood on them. This is the inference that they want the jury to believe. Therefore, someone planted blank socks. So under this evidence planting scenario, maybe what happened was the person that planted the blank socks was listening to the news media and heard this story about DNA testing and thought to themselves, oh my heavens, we planted the socks, but we forgot to plant blood on them. And then as a result of having been reminded by the news story that they had forgotten to plant blood on the socks, got dressed up in their ninja-style evidence planting outfit, and then put the blood on those socks.
All right, well, if you argue that the defense argument is speculative, let's get back onto terra firma.
Well, it's not just speculative, Your Honor, but I don't think that the defense can logically assert that theory, that the news report itself...
Let's agree nobody likes that theory.
Okay. So let's try theory number two then, evidence planting theory number two. And that is that, and it seems to be inconsistent, by the way, with evidence theory number one, which I think the defense in part has pursued, because they've suggested that blank socks were in effect planted. But let's take evidence theory number 2, and let's suggest that what happened was the evidence was planted prior to the time that the news story came out. Then what happened under defense theory number 2 is that the person that planted the evidence on the socks, for some reason, then immediately called the news media and said, guess what, I just planted some evidence on the socks, or guess what, there's evidence on the socks, and it's going to be Nicole Brown's blood. And that seems to be particularly unreasonable to conclude that the very individual that participated in planting the evidence then called the news media to tell them about that. So under either scenario that the defense wants to pursue, whether the evidence was planted after the leak or before the leak itself does not logically help to establish that evidence was in fact planted, because the person that was responsible under theory number 2 for planting the evidence would be the least likely individual to want to do anything to make that fact known and perhaps be caught in the process. So I have suggested that none of these 3 prerequisites can be established. You can't show that it was a leak of DNA test results that in fact occurred. You can't show that the person came from SID. And even if you could show all those things, you still can't logically connect up this so-called leak to the question of evidence planting under any scenario that I can see the defense arguing before this jury. I'd like to get to the other more technical issues, but that would assume that we got over the threshold issue of relevance. I don't know whether the court perhaps would like to divide this up into pieces and decide the issue of relevance first, because then we have some issues involving privilege, hearsay, conclusions and opinion evidence, a variety of technical legal issues that would go to how the defense would try to present this evidence if the court ruled that it was relevant. But I don't know whether the court would choose to, in effect, break up the arguments and decide the issue of relevancy first.
Well, let's look at the spectrum of the evidence that we have here before us. We have, with regards to the sock, we have the testimony of, I recollect it was Detective Looper, that the socks were recovered at his direction because, quote, they were out of place. That's an explanation I've never heard before. We have the offer regarding Mr. MacDonell's testimony that blood in the interior of the sock A is blood that was not powdery, but in a form such that it had to have been, it was not transferred into that fiber by powder means. It was a liquid when it got there. We then have the testimony of Dr. Reeders that, in his opinion, the testing done by Roger Martz with regards to the sock is, in his opinion, indicative of the presence of EDTA. Putting those 3 factors together with the premature claim that RFLP testing shows that Nicole Brown Simpson's blood is on the sock, I mean, that's a pretty plausible offer of proof as far as going further, wouldn't you say? So
No.
You don't think so?
Well, as to the issue of Detective Looper, Your Honor, Detective Looper's testimony that as to him directing people to collect the socks, the court never heard before because it was never relevant before. Of course, Your Honor knows that the prosecution on each one of the factors that the court has raised has counter arguments, and so I understand, and that is not directly relevant to the court's question. What is relevant is the issue of, is the defense allowed to prove, if they can, that the socks are planted? Certainly.
All right. Here's the thing, though. In the scenario that I just posed, the chain of facts or proffered evidence that I've discussed, the next link in this is that there's somebody in the police department who knew about this and told somebody in the news media
Who knew about what?
about the fact that there's blood on the socks
So
in
that's
a premature fashion.
That's scenario number two. What I've talked about is scenario number two, that a person either planted the evidence, him or herself, or had direct knowledge of this and participated in it, and then decided to disclose it to the news media.
But don't we, from this point, then have to make an inquiry of the news source first as to who the source was before we determine how much further down this line we go?
Well, I'd agree, Your Honor, that if the news people said, I received information from Mrs. Smith, who works for SID, that this evidence was on the socks, a couple of the relevancy hurdles that I articulated would be overcome. Because then we do have, in fact, evidence of a leak, rather than just speculation and conjecture and so on that we have to infer what was said. We do have
Mr. Goldberg,
the second...
you should, in making your argument, you should understand that we're not about to conduct this trial by TV news reports.
I would hope so.
But we do have to make inquiry based upon what we've seen here so far of the news media for what their source was.
That's a different issue, Your Honor. And as I was about to say, I agree with the court.
Depending on that, all of this scenario discussion is really premature before we find out what we get from that other source, what, if anything.
I believe that it has been represented, though, to the court and to both sides. I think we got a letter, I don't know whether it was served on the court.
Yes, it was.
From the news organization saying that they would, that they obviously didn't want the witness to testify even to authenticate the tape, but clearly that they would invoke their privilege.
But you are familiar with several cases throughout the country where reporters, despite having identical reporter shield laws, have been forced to divulge sources or face the contempt power of the court. And since it appears this trial may be going on for several months, that could be a significant sanction.
Well, Your Honor, I am not addressing the issue and was not arguing the issue of whether or not the court wants to hold such a hearing and then attempt to get this reporter to divulge their source. That's a separate issue. And obviously, if the answer...
The point I'm making is that before we get to the cross-examination of Michelle Kessler as to news reports, there has to be a little bit more there than what we have now, is the point I'm making.
I'd agree. And I think that the burden is on the proponent of the evidence to get that little bit more in here, however they want to do it.
All right, then procedurally, my understanding is that the news reporter in question has been subpoenaed?
Yes, Your Honor, I believe she has, says Mr. Douglas step out. Ms. Ann indicated they accept service, and I presume that happened yesterday. And normally, I'm sure that's the call.
All right. Then I would say this further discussion about scenarios at this point is really premature before we get that other piece of information.
Okay.
Mr. Uelmen? Let me just cut to the chase. Do you agree procedurally at this point, we perhaps should have a 402 hearing calling the reporter and asking them if they're going to divulge their source, and if not, proceed accordingly?
Your Honor, I think we can make a sufficient showing that the source of this news leak was the SID laboratory without the divulgence of the source by the news reporter.
Okay, how do we do that?
We do it simply by asking Ms. Savage to come in and authenticate the report that was given and to confirm the information which has already been disclosed to this court in the form of a letter addressed to Your Honor from Carol Black, the President and General Manager of KNBC TV. At that time, Ms. Black represented to this court that the news story was based upon, and I'm quoting, individuals knowledgeable about the investigation had told KNBC News personnel that socks with blood on them had been part of the material seized by authorities in Mr. Simpson's house, that DNA testing had been requested to determine whether the blood on the sacks matched the blood of one of the victims, and that communications from the testing laboratory had reported a positive correlation. Now, that is their representation of the sources. They
But
then...
is the source knowledgeable? As
Yes.
Mr. Goldberg points out, that could include Mrs. Robertson.
Well, I'll get to that in a moment.
Not
They-
that she's not a credible source, but, I mean,
Yeah.
there's a whole panoply of people
Well,
who
there's
claim to be
there's
knowledgeable.
another element to this, because they go on to indicate that this same source had previously provided reliable information. They come back and they reconfirm, and they say, our sources reconfirmed to KNBC News their original statements that the tests had occurred and that the communications had been received. Thus, KNBC's news reports were based on the statements of multiple sources with different avenues of information who KNBC knew had knowledge of the investigation and who had on previous occasions provided accurate information to KNBC. Now, I assume that Tracy Savage would also testify that KNBC does not base news reports simply upon lucky guesses or upon crackpots. So we're limiting, at least somewhat, the available pool of sources from whom this information might have emanated. Now, through the testimony of Michelle Kessler, we believe we can establish a chronology that points a very, very reasonable inference of a finger of more than suspicion at the SID laboratory itself, because you have to put this in the context of a chain of events. And that chain of events starts much earlier than September 21st. It starts on September 12th, when Michelle Kessler, as director of the SID laboratory, receives a fax from Cellmark giving DNA results. That faxed report is not even transmitted to the prosecutor, Marcia Clark, until 4 days later, on September 16th. But on September 12th, on the same day that the fax is received by Michelle Kessler, there are news reports, including, I believe, a KNBC news report, reporting the results of those DNA tests. All right, then we're told on September 18th, a PGM subtype of the sock is done, and it turns up results consistent with Nicole Brown Simpson. Now, the question is, who knew of those results? That test was done by Greg Matheson within the SID laboratory. We'd like to ask Michelle Kessler, well, who found out about those PGM results? To whom were those results disseminated? Apparently, the decision was made on September 21st to send the socks out for DNA testing. We would like to know who made that decision and to whom that decision was communicated, because on September 21st, coincidentally, that's the date that the news leak announces DNA results on the sock.
All right, do we have a copy of the fax of September the 12th?
Yes, we do. I believe that was appended to an earlier motion that we filed with the court.
I didn't see it in this round of motions.
I'm sure we can lay our hands on another copy and make a copy of that. We believe that Ms. Kessler would also testify as to the method by which evidence and information of this nature was handled within the SID laboratory, that she would testify that this was a sensitive investigation, that steps were taken so that only those who had a need to know would be informed of information of this nature, and we would like to ascertain just who had a need to know under these circumstances. I believe we can limit the pool of available sources to a very small group of people from whom this information could possibly have emanated, who would have known.
The problem we have, though, is that this information was just flat out wrong.
Well, the information was wrong only in a couple of minor details, including the detail that the tests had already been done and that the socks had been sent to a particular laboratory. But the discovery...
But in all other respects, it was correct.
Well, it was correct in terms of the discovery, alleged discovery of blood on the socks. It was correct in the
But that was known
attempt...
in August.
Well, it was correct in the attempt to link that blood to Nicole Brown, which would have been only known to those who had access to the PGM subtype results that were achieved on September 18th.
Well, let me ask you this. Do you want to pursue dragging Tracy Savage in here and asking her to divulge or not? Do you want to pursue this other indirect line?
Yes, we do want to pursue bringing Tracy Savage in, but we believe it's not even going to be necessary to require her to divulge the identity of the source. All she has to do is confirm the information that has already been disclosed.
Do you think I'm going to allow playing that news broadcast to the jury as evidence in this case?
Yes, I think you are, and you should.
Under what plausible grounds could I do that?
Well, it's not being offered certainly for the truth of what is asserted in that news broadcast, so it is not hearsay. It is being offered to show the link in the chain with respect to the planting of evidence in this case, Your Honor. We have to put this in the context, as Your Honor has already noted, of other evidence. When I was a prosecutor, I used to love the metaphor of a brick in the wall, and that you can't keep out evidence because it's only a brick and it's not a wall, that all of the inferences and circumstances go together in a circumstantial case to build a wall. We are now engaged, Your Honor, in removing bricks from the wall. We are engaged in the process of creating a reasonable doubt, and that's all we have to do.
Nice analogy. Tell me what your legal basis is for me allowing news broadcasts that are fabrications as evidence.
Because those fabrications emanated from someone in the SID laboratory, which is where we would contend evidence fabrication took place. Now, we have...
Do you think there are a lot of people who have an interest in this case who have a personal interest in seeming knowledgeable and cultivating media attention who go out and lie to the news media about this case? You think that's a phenomenon
Mr.
that
Goldberg
might have
suggests
occurred?
that perhaps there are
Thank you.
eavesdroppers and interlopers. Now, if eavesdroppers and interlopers had access to the evidence in this case, that is something we'd like to know about, because the existence of possible eavesdroppers or interlopers may itself create some doubts about the integrity of the evidence and the question of whether evidence was planted. But the fact remains, Your Honor, that we believe we can establish within the SID laboratory, within the very small pool of people who had access to this information, who could reasonably have been the source of this leak, that the leak itself creates an inference that evidence was being fabricated. That somebody would have enough confidence to tell the news that there will be positive DNA results on a sock indicates a high degree of confidence that that's what the results will show. And that confidence could have come from involvement in actually putting that evidence there and knowing in advance that that's precisely the result they're going to get, because they ensured in advance that that would be the result. And we believe that is not a speculative or unreasonable inference in light of all of the other inferences that we have with respect to the sock. We have the discrepancy in when and where the sock was found, and that evidence isn't relevant just to create some scenario, as Mr. Goldberg suggested, that somebody planted a blank sock.
No, I dismiss that as
What that
completely
evidence
ridiculous.
does is suggest to the jury that this sock, as well as other evidence, was not particularly handled with great care, that we cannot trust the evidence and the records of the criminalists who say they collected that sock when we've proven that those records are wrong, that they have the wrong time, with respect to when those socks were collected. Then we have discrepancies in terms of when blood was discovered on the socks.
Well, counsel, let's get back to my question. What legal, statutory, case law, other example that any court anywhere in this country has ever allowed a fabricated news report as evidence in a case? Ever?
I'm sure we can come up with cases where news reports have been admitted for a non-hearsay purpose, and that's...
Give me one.
I'll get right to work on that, Your Honor. What we're offering this news report to establish is that the SID laboratory was the only logical source of that information, that the pool of individuals within that laboratory
I understand the argument.
were persons who had access to the evidence and could have participated in the planting of evidence. So we're simply adding or subtracting another brick from the wall that creates that hole of reasonable doubt. That gives this jury a reasonable doubt as to the integrity of the evidence that is being presented in this case. And the news leak is crucial to establishing that additional inference. I mean, you can't, in terms of our obligation of creating reasonable doubt, draw circles around what bricks we can displace from the wall that the prosecution is attempting to build. And this is a very important brick. The brick that suggests that the SID laboratory maintained tight security over the evidence, that the evidence was not available to others, that information about the case was tightly controlled. And here we're rebutting that inference, I think with very persuasive evidence, that there were leaks from that laboratory, and those leaks create doubts about the integrity of this evidence.
All right. So how do you want to proceed at this point?
We would like to proceed by calling Tracy Savage, by asking her to authenticate the news tape, by asking her whether KNBC bases news reports of this nature on lucky guesses or on crackpots, and to confirm the information that was disclosed to this court in the letter of Carol Black, that this information came from a knowledgeable source about the investigation, and that source had given prior information to KNBC, which turned out to be reliable. We would then proceed to call Michelle Kessler to inquire as to who were the persons within the laboratory who had any information about DNA results, who had access to the faxed DNA results on September 12th, who had access to the PGM subtype test done on September 18th, who had knowledge of the decision to send the sock out for DNA testing on September 21st. We believe that will be a very limited pool of possible sources, and that's all we need.
Mr. Cochran, what's the status of your subpoena for Ms. Savage?
Mr. Douglas advised me that she was served, I believe, Tuesday this week through counsel for NBC, and if the court would like, I can make some phone calls if you give us a schedule. They've indicated that she's usually in and around this building, but apparently she is now under subpoena.
All right. When do you want to proceed? I think there's a very necessary step that's missing here.
You've heard Mr. Uelmen's arguments. You're the judge. We'd like to proceed as soon as possible, obviously, I'm not sure, given the schedule we have Dr. MacDonell, Professor MacDonell here, but we'll work around that, and we'll have a short day tomorrow. So you let us know what the schedule, what's appropriate, and we'll work around it.
My recollection is we have to conclude Dr. Reeder's tomorrow morning.
We do.
Want to present Mr. MacDonald today,
That's correct.
And my recollection is he's from out of town as well, correct?
Yes, they're both from out of town.
All right, let's go with MacDonald. When we take our recess, we'll come back at 10:30, we'll start with Mr. MacDonell. Council, once you make arrangements, I take it, is Kessler your next witness after MacDonell and Reeders?
I would think so, yes, Your Honor. With Savage Kessler. Yes, Your Honor.
All right, then let's go Monday with this.
Monday morning, 9 o'clock,
Monday morning, 9 o'clock.
depending what happens tomorrow, but yes,
But that'll be for the 402 hearing regarding what comes out of Savage.
that'll be fine.
All right.
Sorry,
There's,
Jerry.
There is one more matter, I believe, this morning, Your Honor. I served Mr. Cochran with a subpoena ducis tecum. Did the court have an opportunity to see that? I filed it with the court yesterday so that you could take a look.
Yes.
As the interview that was conducted by the DAI, as that little typewritten statement says, the witness, Gretchen Stockdale, confirmed the truth of what was reported in the, is it the New York Daily News article? On May 13th, indicating that Mr. Simpson had called Ms. Stockdale saying that he was finally in a place in his life where he's totally unattached with everybody and so forth. So that's information that the prosecution, that tape, which Ms. Stockdale made of that phone conversation, is evidence, which the prosecution has a right to. This witness said that she had only one copy, and she gave that sole copy to Mr. Pavlik, the defense investigator. So we are not trying to use the subpoena process for discovery. We're trying to get evidence which we already know from an independent source exists, and the only copy of which was given to the defense.
Your Honor, our position on this is completely consistent with the position asserted by the prosecution in response to defense subpoenas, and that is that the reciprocal discovery law itself specifically provides that it is to be the exclusive means of obtaining discovery of evidence. And the appropriate way to proceed in this case is by a discovery request. Our position, of course, would be that this is not evidence that we are required to disclose, that it is rebuttal evidence in case this witness is called. It is not evidence of the crime within the meaning of the Meredith case that the defense has any obligation to turn over, and we do not intend to call Gretchen Stockdale as a witness, so there was no obligation under the discovery law to turn this over.
Oh, Your Honor, this is physical evidence that the prosecution has a right to. They can't shield evidence by having a witness give it to them and hide it from the prosecution. The witness did voluntarily interview with us, and she indicated this is where this particular cassette tape went. We're not in the situation of discovery at all, really, with regard to this cassette tape.
All right, so I think what you need to do is file a motion to compel the production of this tape. I agree with Mr. Uelmen, the subpoena ducis tecum upon defense counsel is not a mechanism authorized by 1054. All right. All right, let's take a recess for 15, and we'll start with Mr. MacDonell. Yes.
I'm informed that among the items of evidence that we'd like to put on today is the videotape and the grand jury testimony of Thano Paradas. And I understand that the prosecution has taken the position that they want to offer some additional statements pursuant to 1202. Our position, and I think Your Honor can rule on it at this time, is that that's appropriate for their rebuttal case, but the admission of this videotape and the grand jury testimony as former testimony does not depend upon the availability or presentation of any impeaching evidence that they would like to present, that can be done in the course of their rebuttal case. We were not allowed to interrupt the presentation of their case in chief by bringing in witnesses that we assert would impeach the credibility of any of their witnesses. We'd like to proceed with our case with the presentation of this evidence, and if they want to offer something to rebut or impeach it, they can do that during their rebuttal case.
All right. Who's going to address that matter for the people?
Your Honor, first of all, I'm not sure that the people were told, maybe Ms. Clark was, that they intended to put on the transcript testimony of Thanoprodis today.
No, we've discussed it
That
as
that was
coming
going-
after
that
MacDonell.
was going to be today.
Not necessarily today, but following MacDonell.
Oh, okay. Well, then that might not necessarily be today, I would assume.
Well, we may not finish MacDonell today, at
Right.
the rate we're going.
But at any rate, Your Honor, I did not research the specific issue that counsel has addressed as to the appropriate mechanism in terms of order of proof for dealing with the hearsay declarant. What we do know is that we know that the court has statutory authority to control the order of proof. That we can be positive of. And we also know that if Thanoprodis were to have come into this courtroom, as opposed to having his testimony presented through the transcripts, that Mr. Paradas could be asked about prior inconsistent statements on the witness stand, and therefore those statements could be put in front of the jury immediately during the presentation of that particular witness. Obviously, we can't do that with the hearsay declarant because we're never going to be able to confront him with the prior inconsistent statements. Nevertheless, we are statutorily entitled to call a witness who can testify to those statements. What I would say to the court is that given that the court does have statutory authority to control the manner of proof, and because the court has in effect made a ruling or there has been a finding of unavailability, the prosecution should be able to present those prior inconsistent statements at the same stage in the trial that we would be able to present them if he were here live. That is immediately upon the heels of what would be his direct testimony, the reading of the transcript. Now, the other issue that's raised by what Mr. Uelmen just stated to the court is the question of whether or not the grand jury testimony is admissible. That was not subject to both direct and cross-examination, obviously. So I'm not sure that the grand jury testimony, as opposed to the preliminary hearing, is admissible per se, although I'm not certain whether the people would have an objection to that. I'd like the opportunity to take a second look at that, or perhaps another member of our prosecution team to determine whether tactically we would want to make that objection.
All right, we'll take that up at the conclusion of Mr. MacDonald's testimony then, whenever that might be. But be prepared to tell me what your position is regarding the grand jury aspect as soon as you can. Let me just make this one observation, though, about order of proof. This witness was available to the prosecution in their case in chief. The testimony by Mr. Paradas could have been presented, his testimony now that his recollection is X, Y, and Z as far as how much blood was collected from Mr. Simpson. And then he could have been, during the direct examination, asked about prior testimony. He could have testified how he was mistaken or whatever the offer might have been. That opportunity was available to the prosecution. They did not avail themselves of that. Any 1202 evidence, assuming that it's admissible, will be restricted to the prosecution's case in rebuttal. All right.
We have not, at this point, received any statements or any offer of proof with respect to 1202, so we're completely in the dark
Well, it
as
could
to whatever it is they're going to offer.
be rebuttal evidence that they don't have to disclose to you at this point.
Well, if it's
So
rebuttal,
depending on how you want to play this,
if it's rebuttal evidence, then it should await their rebuttal case.
probably should. All right, we'll take.
We did say, and so that your Honor was clear on that day, we did say if we ran out of time on Agent Marks, we would even call Ms. Paradas thing yesterday.
Yep, I recollect. But I also said I wanted to see it one more time before we
Sure,
play it.
we'll make it.
My recollection is 8 or 9 minutes. No, we're going to take a recess for 10 minutes. All right, thank you. 10.
Good morning, Your Honor. Just 1 second. I'm asking Mr. Harris to actually get a couple of boards, which are currently not up here, so I'm going to show him the photographs of the boards. Good morning, Your Honor.
Neufeld.
Our next witness is Professor Herbert MacDonell, and there are a couple of points I wanted to get out of the way first, Your Honor, in the nature of 402 and in limiting matters. First of all, I think you may recall I mentioned in front of Ms. Clark yesterday that this witness will not be testifying at all to any crime scene reconstruction at Bundy, and that I believe, therefore, that would be beyond the scope of cross-examination, and I wanted to have that issue resolved before I called the witness, because it doesn't go to impeachment, and he's not their witness, he's our witness. So that's the first issue. The second issue, Your Honor, is that, as you know, Professor MacDonald conducted a glove shrinkage experiment, and although that may open the door to the prosecution conducting its own glove shrinking experiment with the gloves that they have, I don't believe it opens the door to displaying other photographs that they have or purport to have of Mrs. Simpson wearing leather gloves in different places. One has nothing to do with the other. This experiment is being this experiment is being introduced for a very limited purpose, so I would like a ruling on that. And third, Your Honor, I would ask for a ruling in advance of me calling this witness as to which cases the prosecution would be entitled to bring up on cross-examination. I'm not asking for transcripts now. I'm just asking for certain cases, because Professor MacDonald has been involved as an expert witness on behalf of the prosecution and behalf of the defense in many well-known cases throughout the country. And I want to make sure that if other cases are brought up, they're brought up because they're in fact relevant and probative, either directly or as impeachment purposes, and are not simply brought up to create innuendos about his involvement in one case as opposed to another case because of the name of the victim or the name of the defendant, which would be completely irrelevant in these proceedings. And that's why I'm asking for a ruling in advance of which cases the prosecution intends to go into.
All right.
Thank you.
Ms. Clark?
I don't really understand how counsel can require us to state what we intend to use to impeach a witness who has given us no report, who has given us no indication of what he's going to testify to. We are here in the blind, as the court is well aware. Certain topics have been referred to, that he will address this topic or that topic, telling me nothing of what he intends to say about that topic. And in view of the fact that they have determined it's appropriate to keep us in the blind and not tell us what he intends to testify to, I cannot be in a position to accurately inform them of what I intend to impeach with. That's what I have to say about the cases we intend to use. I don't know. If he would tell me what he was going to say, if counsel had been forthright and candid about what he was going to testify to and what his conclusions would be, I might be in some position to help them, but I can't. With respect to the crime scene at Bundy, again, how do we know what he's going to say? Some comparison to the blood drops at Bundy or something present at that crime scene might be relevant impeachment, given some conclusions he makes about what he sees at Rockingham. And until we hear that, we don't know. This is what they have bought into by failing to tell us or give us any reports as to his conclusions. How can I know what I'm going to use to impeach or ask to use to impeach? With respect to the glove photographs, any, I think, photograph or any evidence that is relevant to impeach the experiment that they undertook to conduct is, I think, fair game. They have undertaken an experiment in which they took a brand new pair of gloves that fit Mr. MacDonell very differently than the gloves fit Mr. Simpson when they were first purchased for him by Nicole. And all of the differences that are accounted for by the fact that new gloves were used in their experiment and old gloves were obviously the ones used in the crime should obviously be fair impeachment, not to mention photographs that may depict the conditions that those gloves were subjected to. Counsel can't have it both ways. You want to come in and use an experiment that is so easily impeached by the dissimilarity of the conditions, then this is what happens. The dissimilarity of the conditions should be brought forth to show the jury that this is worthy of no weight. Can't have it both ways, though, and try to insulate yourself from cross-examination, which is basically what counsel's asking to do. We want to put this evidence on, but you can't impeach us. That's not the way the law works. So that is our response. I think that any relevant impeachment should be allowed, but until we know what he says, we don't know what that is. May I also address the court on another matter, and that is the expert has given us no report on his conclusions concerning what he saw at Rockingham, what he saw in the Bronco photographs. I think the only notes we even have from him are the glove drying experiment. That's the only thing that they intend to present from him that we have some kind of written material on, and the observations of sake. So really, it sounds to me like the bulk of his testimony is unreported and unnoted in any document. In light of that fact, Your Honor, the people have no chance to prepare. And in order for the people to have the right to a fair trial and to be prepared to adequately cross-examine and confront the witness, I think I'm asking the court leave under the old laws. This is not even under the new statutory discovery laws, which compel counsel to produce discovery. Even under the old laws, when an expert testified and gave late discovery of a report or no report, the people would be entitled to some time to prepare for cross-examination and not be required to stand up and cross-examine immediately after direct was concluded without having had some adequate opportunity.
But isn't that an issue we need to address after we've heard the direct examination to see what the extent is? I mean, who knows? Mr. MacDonell may present evidence that you're completely adequately equipped to address.
Well, given the fact that two of the major areas they intend to address have no reports or notes, I can't imagine that being the case, but I get that the court wants us to wait on this.
Well, you're asking me to make a premature judgment as to what's going to be there. It may be something so simple and logical to deal with that even I could do it.
I don't share the court's, the humbleness of the court's self-characterization, but we'll wait and see.
Let's wait and see.
All right.
All right, Mr. Neufeld, in answer to your questions, without hearing the testimony, it's hard for me to circumscribe or give you a ruling with regards to the scope of cross-examination. With regards to Bundy, I agree under normal circumstances, if you don't present any testimony as to any evidence at Bundy, then that's probably not fair game. But if there is a comparison, for example, between blood drops at Rockingham and their appearance versus the blood drops at Bundy, and if there's any difference, if that becomes relevant, that might be fair game. I don't know. With regards to the glove shrinkage, you've asked me to some concern about pictures of the defendant wearing gloves. You know, as we pointed out in our discussions about gloves, you know, the experiment was conducted on a new pair of gloves. There are pictures of Mr. Simpson that the prosecution has alluded to wearing gloves in winter weather, which may be one of the factors, you know, snow, moisture may be one of the things you have to take into consideration as to whether or not gloves are going to shrink over time. I don't know. But before that is broached in cross-examination, I'm going to ask Ms. Clark as to any cross-examination regarding the Bundy crime scene, any photographs of the defendant wearing gloves, and any transcripts that you might have on other cases that Mr. MacDonell has testified to. I want you to notify the court and approach so that we can examine that before we go any further.
Right, just two things very briefly.
Yes.
One is, so as you know, there were reports turned over about the bulk of what Professor MacDonell will be testifying to. And I conveyed to the court and to the prosecution that that is the reality of what you're about to hear, and I assure the court once again that it is that. And for the people to make this assertion that they've had no reports and no notes really isn't a fair statement.
Well, counsel, as I indicated to you, any request for continuance for preparation of cross-examination is after I've heard the direct, and let's see what it is.
We have a brief sidebar, Your Honor.
For what purpose?
I would just like to bring up one matter with the court, which I'd like to do a sidebar if it's possible.
MacDonell, let's have the jury, please. Let the record reflect that we've now been rejoined by all the members of our jury panel. Good morning, ladies and gentlemen. My apologies for having kept you waiting upstairs so long. We had a number of motions to take care of out of your presence. We did conclude most of them, and we'll proceed with the next witness. Mr. Neufeld, you may call the defense next witness.
Defense calls Herbert MacDonell.
Raise your right hand, please. You do solemnly swear that the testimony you may give in the cause now pending before this court shall be the truth, the whole truth, and nothing but the truth, so help you God? I do, so help me God. Please have a seat in the witness stand and state and swear your first and last names for the record.
My first name is Herbert. The last name is MacDonell, capital M-A-C, capital D-O-N-E-L-L.
Mr. Neufeld.
Good morning, ladies and gentlemen. Sir, could you, I guess you already gave your name. Could you please tell the ladies and gentlemen of the jury where you live, sir?
I live in upstate New York, in Corning, New York by name.
And could you please tell them what is your occupation?
I'm director of the Laboratory of Forensic Science, which is an independent laboratory available to both prosecution and defense in criminal and civil cases. And I have been involved in cases other than civil and criminal, mainly private.
Do you also hold any other business titles, sir?
Yes, I'm president of what is called MacDonell Associates Incorporated, a company that manufactures fingerprint equipment that I invented some years ago.
Do you have a degree from a recognized university or college, sir?
Yes, I have a Master of Science from the University of Rhode Island, a major in analytical chemistry, and a minor in physics, a Bachelor of Arts degree from Alfred University in upstate New York, with a major in chemistry and a minor in mathematics.
And do you have any other formal education beyond those degrees, sir?
Yes, I have taken many courses under the state municipal police training councils, such as Pennsylvania and New York, and also I took a 10-month program under the Department of Attorney General of the state of Rhode Island, dealing with what was then called criminalistics, and the course involved mainly physical evidence.
Have you conducted any teaching on a college or university level?
Yes, I was professor of chemistry and head of the department of a small Midwest college in Milton, Wisconsin for 3 years, and other than graduate work, I began teaching at Corning Community College, a 2-year school under the State University of New York, from 1960 to 1992, with a 5-year sabbatical in there off and on. I also taught at a 4-year school in upstate New York, Elmira College. That was from 1972 to 1983. At that institution, I taught many forensic courses, 10 specifically.
So in all, you said you started teaching in 1951 when you were the
Yes.
chairman of the department at Milton College?
Yes.
And are you still teaching today, sir?
I'm teaching, but not with any college or university. I run institutes, specialized schools that are usually 1 week in duration, and conduct many workshops and seminars of 1, 2, and 3, 4-day duration. But I'm not currently affiliated with any particular college.
All right, we'll come back to that other institute later, sir, but you mentioned that you began in 1951 as a professor and head of the department at Milton College, and you finished your last professorship, was in what year, sir?
1992.
Okay, so you were teaching on and off for approximately how many years?
35 years, depending on whether you deduct these sabbaticals or not.
All right, even though you're not technically teaching right now, having taught for 40 years as a professor, do people still address you as professor?
Yes, they...
Sustained. Phrase the question.
Given the duration of time that you actually were a professor, since 1951, as a result of that, do people refer to you as professor?
Yes, quite frequently they do. I've referred to as doctor many times. I do not have a doctor's degree, but I receive this title quite often, and it's embarrassing to either correct the person or ignore it. It's
Right.
a difficult choice sometimes.
Professor MacDonald, what experience have you had in the field of scientific crime investigation?
Well, when I went to the University of Rhode Island in 1954, I worked for 2 years in the State Crime Laboratory in Kingston. It was located at the University of Rhode Island. I worked with Dr. Harrison, who was director of the crime lab, and my master's thesis was on forensic applications of bloodstain pattern and typing and so on. Dr. Harrison conducted the courses in criminalistics, and in the process of taking the courses, we very often worked on cases together around the area of the state of Rhode Island. In 1957, I began consulting on a more frequent basis and have done so ever since.
And I take it you belong to a number of professional societies.
Yes, I do
All
quite.
right, now I don't want you to list them all, sir, but are there any societies in particular which you feel are relevant to the testimony you're about to give in this case?
Well, I'm a fellow in the American Academy of Forensic Sciences. I have been for over 31 years, a member several years before that. I am a member of the International Association of Bloodstain Pattern Analysts.
Could you please tell the ladies and gentlemen of the jury what that second association is?
That's an association that was founded to encourage people who have studied the subject of interpreting bloodstain patterns, not serology, but the geometry of bloodstains. It was founded in 1983 at the request of many of my former students to have additional training. So we conducted an advanced school, and during the first advanced school in November 1983, this association was founded. It now has anywhere from 250 to 400 members. I'm not sure the total because some drop in and some drop out, and the ones that don't pay their dues aren't on the roster, so it's at least 250.
And do you have a special title in regards to the International Association of Bloodstain Pattern Analysts?
Yes, I'm the historian. I have been since the organization was founded. I'm also classified as a distinguished member of that association.
What does it mean to be a distinguished member of that association, sir?
It's recognized by your peers as having made substantial contributions to the subject or discipline of interpreting bloodstain patterns.
Are there any other people in this 200 to 400 member International Association of Bloodstain Analysts who have the title of distinguished member?
No, not at the present time.
Now, have you authored any technical articles on forensic science?
Yes, I have quite a few.
Approximately how many?
I think my curriculum vitae says 95. I think it's well over 100 by now.
Have you authored any chapters in books or books themselves on the subject of forensic science?
Yes, I included those in the 100. Quite a few chapters.
Have you authored any books on the subject of blood stain interpretation?
Yes, I issued initially a report for the Department of Justice that was, I would call it a pamphlet, or being very kind, a booklet. It was only 77 pages, but it included the results of 2 years of research for the Law Enforcement Assistance Administration under the Department of Justice. And since then, I have revised that 1983, and most recently 1993. I completely rewrote the text, and it's now approximately 200 pages, I think perhaps a little more.
And has that textbook on bloodstain interpretation been translated into foreign languages?
Yes, I know it's been translated into Swedish, German, and Spanish. I'm not sure about French.
And do you know whether or not that textbook that you wrote on bloodstain interpretation is used by law enforcement agencies throughout the world?
I think so. That's why I get a lot of students.
Now, in addition to your writing and your publication of books on the subject of bloodstain interpretation, Professor MacDonald, have you ever lectured on the subject of forensic science before any recognized professional organizations?
Yes, I have quite frequently.
And have you lectured on that same subject outside this country as well?
Oh, yes, many times in Australia, New Zealand, Europe in general, London, England, Scotland Yard, the United States, many states in the United States.
Sir, are you certified by any recognized forensic organization?
Yes, I'm certified as a senior crime scene analyst by the International Association for Identification.
And what is the International Association of Identification, sir?
It's the largest organization comprised of fingerprint identification technicians, photographers who go to crime scenes, people who would be involved in accident reconstruction or crime scene reconstruction, firearms identification experts, people that do question documents examination. It all has to do with identification in general, but it's more specifically fingerprinting in particular. It's a very large organization. It has membership all over the world.
Sir, have you ever received any awards in your particular field of forensic science?
Yes, I have.
Now, I'm asking you this one. Is there any particular award in the area of forensic science that you are particularly proud of?
Well, I'm always grateful and proud for all of them, but to say the most important, specifically in forensic area,
Yes, in forensic science.
I would say the John Dondero Award, which is given by the International Association for Identification, which I received in 1974 in Washington, would be the one that I think is the one I hold most dear.
Is that award given out every year?
No, it's given when they feel someone should receive it.
And who was the first recipient of that award, sir?
John Edgar Hoover, the director then at the time, 1957, he was given the first one. He was director of the FBI at the time.
Now, you said you received it in 1974?
Yes.
Now, you've heard the names since you've become involved in this case of some of the experts who have become involved as well for both sides.
Yes, I have.
Are you aware of any other expert who's involved in this case who has also won the Dondero Award?
The only one that I know is involved is Dr. Henry Lee. If someone else has received it, I apologize to them because I did not check the list for that particular question.
Now, in particular, as a criminalist, sir, what experience have you had with human blood as evidence?
I began actually working with human blood during my master's thesis at the University of Rhode Island, where I effectively did what is now called immunoelectrophoresis. And in that process, we created many blood stains so we could analyze them. But in the process of creating them, we were aware of the geometry that results from different events, different angular impact, and so on. So I began then, but as far as studying the geometry specifically, that began in 1966 when I had a case that I knew the patterns told me something, but I just did not know what. So I began doing research the same way Dr. Petrowski did in Poland for the same reason. That was 1895. He did the same thing. He had a case he didn't understand, at least that's in his text. And so he did a lot of research too. It was not original with me. Many people have done this long before I did. I just was not aware of it. So I began actively working in 1966 and continued on, and I was asked in a meeting in Toronto in 1969 to apply for a grant from the government to pursue this specific subject of interpreting the geometry of bloodstains, the cause-effect relationship. And after I did that, and it was published and distributed worldwide by the Superintendent of Documents, I had a lot more research to do. People continually brought cases to us.
Now, Professor MacDonell, you mentioned before something about an institute. Are you currently teaching, and have you been teaching for some period of time, the discipline known as human bloodstain interpretation?
Yes, as a direct result of the 1971 publication, it was called Flight Characteristics and Stain Patterns of Human Blood, I was asked first by the Law Enforcement Assistance Administration in Mississippi to come down and teach what I had written, and I did. In March 1973, I conducted what we call the first Bloodstain Institute. It was an institute on the physical significance of bloodstain patterns. It's a longer title. We refer to it as the Bloodstain Institute. And directly following that, in the spring of the next year, or later in the same year, and in the spring of the next year, there was a demand from students who wished to study with me on this subject. And to date, I've conducted 43 of these. We have another one scheduled in September. The last one was in Sweden at the National Police College in Sweden in May and in June. The one in May was in Corning. The one in January was at the University of New Haven. We've run these in, I think, 13 states, the District of Columbia, and in Australia and in Sweden, and currently negotiating to run them in Denmark and Norway.
And generally, who are your students at these various institutes that you run in this country?
These would be mainly law enforcement personnel. They might be in a crime lab, a serologist, an evidence technician that would go to the crime scene. We have had many forensic pathologists attend. We've had lawyers. We've even had a veterinarian. So there's no restriction on who can apply, but they're welcome to come and learn. What they do with that knowledge, of course, is something else. I don't know what they will do.
Sir, in your capacity as a consulting criminalist, have you ever had occasion to present expert testimony on the subject of human blood-stained evidence interpretation?
Yes, I have.
Approximately, do you have any idea how many times, or at least in how many states?
On that particular subject, I would say conservatively 150 times in 32 states and 3 foreign countries.
And who generally retains you in these cases, sir?
Initially, I was retained by the prosecution more than the defense, and as I trained more and more prosecution, I won't say prosecution, I've trained more and more laboratory personnel who would be called by the prosecution. It's become less and less difficult for the prosecution to find their own expert and not call me. So currently I'm called less by the prosecution and more by the defense, but that is just the number of times I may be asked to investigate a case. It's not the number of times I testify by any stretch of the imagination.
By the way, Professor, you mentioned that in your very early work, back in 1954-55, you did something involving electrophoresis. Would that fall into the category of serology?
Yes, it would be serology, but that's the last contact I've had with serology, except for doing routine blood grouping tests on wet blood, not even on blood stains, so I'm not a serologist.
Okay. Could you explain briefly to the ladies and gentlemen of the jury the difference between serology and blood-stain evidence interpretation?
Serology is basically chemical reactions, serological reaction, immunological reactions, how one blood group reacts with another, or how blood clots and how it behaves in general. Bloodstain pattern interpretation is concerned only with the static aftermath. When blood is divided up into smaller and smaller spots or droplets that produce small spots, we're interested in the cause and effect relationship. And knowing the size, the shape, the distribution of blood stains of any size, we can generally determine the kind of activity that could have produced it. We can't say a specific activity did this, but we can more often than not say, this could not have done it, but here's 1, 2, 3, 4 things that could have done it. We study, as I said, size, shape, and distribution. Size will give you an idea of the energy available. Large drops, passive drops falling, there's no active energy other than gravity. If you have an impact from a beating or a stabbing, the viscosity and the surface tension of blood come into play. Surface tension is what holds blood together, like it does water or any other liquid. If you have energy to break the surface tension, it'll subdivide into smaller and smaller particles. If you have a lot of energy, like a gunshot impact, then you have sufficient energy to literally atomize mist or create a fog, a fine spray that is very characteristic of high energy. Most often, gunshot, but not limited to gunshot, hand grenades, bombs, other such things, airplane propellers will do the same thing. We've seen all of those. So the size gives you the energy, the shape gives you the directionality, which you can trace back usually to an origin. Knowing the ellipticity or the distortion of the circular spot, we can project the angle of impact back and estimate the origin, say above the floor or from a wall, based upon the shape. The distribution, the fanning out or dispersion, comes back to a common point of origin in 2 dimensions, which we then can convert to 3 dimensions. But it also involves the dispersion and concentration. The more concentrated the spots are, the closer you are to the origin. And then there are infinite numbers of transfer patterns from fingerprints, palm prints to tool marks and Your imagination can be the equivalent of putting something on an ink pad and transferring it to another surface. It doesn't matter whether it's an appendage of a human being or a knife blade or a ballpoint pen or a claw hammer. So
Professor MacDonell, let me see if I can just simplify a little bit. There's been testimony in this case by a number of witnesses about conventional genetic markers and DNA genetic markers. Is that something that's in the field of serology?
absolutely, I don't understand a bit of it.
Okay. And on the other hand, your work involves sort of actually analyzing bloodstain forms, shapes, how they got there, that kind of thing, once they actually leave the body. Is that right?
That's correct. When the blood is out of the body, it's physics. When it's in the body, it's medicine.
Okay. And sir, you mentioned generally how many times you've testified as an expert. Have you also testified a number of times as an expert in this state, in California?
In this case? In
No, in the state of
Oh,
California.
in the state of California? Yes, I have.
Okay. Do you know how many times you've testified approximately?
Yes, I have. I've testified 21 times. One was a hearing, and I think maybe two were hearings. They were in court. One was in court, one was not. But for the most part, they've been in a court of law.
And of those 21 times, do you know how many of them were for the prosecution? Were you an expert for the prosecution? And how many of those were you an expert for the defense?
I think 9 were from the prosecution, and that number varies because, to be fair, sometimes I testified more than once in the same case, not the next day, but maybe a week or a month or a year later. So if you take the 3 times I testified, for example, in a case, if I call that a case, then the percentages vary a little bit. So it's anywhere from 40 to 47% for the prosecution and the difference for the defense.
Were you retained by Mr. Simpson's attorneys in this case, sir?
Yes, I was.
And approximately when were you retained?
In late August of 1994.
That's when you began consulting?
In this case, yeah.
Okay, that's what I meant. And since last August, how much have you been paid for your expertise, sir?
So far, I've received $10,500.
And that would cover since last August.
Well, it's not current. I've made 2 trips since then and done a few experiments, so it's really not up to date, but that is what I've been paid. That was your question.
Okay. Now, sir, in connection with your work in this case, did you, on April 2nd of 1995, conduct an examination of the socks, which are commonly referred to as item 13, socks recovered from the bedroom of Mr. Simpson?
Yes, I did.
And where did this examination occur, and who was present?
Well, I'd have to consult my notes to be sure of the names, but it was here in the Los Angeles area. It was at the Technical Associates Incorporated Forensic Laboratory in Altadena, California, and present were Dr. Henry Lee, Peter Neufeld, Mark Taylor, and Greg Matheson.
And at that point, the person who actually brought the evidence to the laboratory, would that be Mr. Matheson from the
Yes,
Los
it
Angeles
was.
Police Department SID laboratory?
Correct.
And did Mr. Matheson actually unpackage that evidence for your inspection?
I'm not sure whether he did or Dr. Lee did, because I think it was done in more than one bag. He may have opened the first one, and Dr. Lee or Mark Scott Taylor may have opened the second one.
When you examined the socks on that occasion on April 2nd, did you specifically examine sock 13A, also known as sock 42A by Mr. Sims of the Department of Justice?
Yes, I did.
And when you examined that sock, did you specifically examine an ankle stain, which had already been DNA typed consistent with Nicole Brown Simpson?
Yes, I did.
And was that ankle stain, did it have a portion of it cut out?
Yes, there was a rather irregular area cut out that was basically rectangular with another rectangular appendage sort of on one side of the long dimension.
And were you able to see the remaining portion of that ankle stain with the naked eye?
Oh, yes, yes.
During the April 2nd examination with you and Dr. Henry Lee, did you use microscopes to assist you?
Yes, we used microscopes. I used my hand magnifier and high-intensity illumination. But we used microscopes, compound microscopes, stereobinocular microscopes to be specific.
And were photographs taken through the microscope that day?
Yes, the microscope Dr. Lee had a camera attachment, and we did take pictures.
And did you both look through each other's microscopes?
Yes, we alternated. If I found something that I thought Dr. Lee should see, I directed him to see what I'd just been observing, and vice versa.
And were photographs also taken without the aid of the microscope?
Yes, there were.
Now, sir, have you had an opportunity to review portions of the Department of Justice serologist Gary Sims' testimony in this case? Portions of it.
Yes, I've read it. I've read quite a few. I had to stop and think a moment which one that was. Yes.
Are you aware, sir, that Gary Sims testified that bloodstains on this sock may be spatter stains?
Yes, I am.
Citation, counsel. Citation.
Yeah, 1 second.
There's been no offer that he's used anything.
7726 is a description of
You want
spatter.
to show that to Ms. Clark, please?
Were you aware that Mr. Sims said that what he saw were spatter stains or something along those lines?
Yes.
All right. In your opinion, Professor MacDonell, is the ankle stain that you saw a spatter stain?
Not based upon just what you've said or my examination. The examination,
Overruled. Overruled.
No.
not based upon the examination that I made of the socks at that time. I did not find any distribution of blood that I could consider a spatter. I've seen other more convincing evidence of it.
Okay. Now, with respect to the ankle stain, I want you to focus on that. In your opinion, was the ankle stain a spatter stain?
Oh, no, not the ankle stain. I thought you meant the entire stocking.
No, I'm focusing now on the ankle stain in particular.
Oh, the ankle stain was very large. It was not spatter.
Could-
That calls for speculation. This witness only saw a hole. There's no stain there. It's cut out.
Overruled.
Professor MacDonell, first of all, was there stain surrounding the perimeter of the hole that was cut out?
Yes, the cutout was taken out of the middle of the stain. It's the way you usually do it.
And are you aware that Mr. Sims has already testified that there was blood stain on the perimeter of that cutout area?
Yes, I am.
Could you please define what spatter is?
Spatter is simply the result of impact to usually a liquid. In this instance, we're discussing blood, and it creates a spray of small drops, not like gunshot, but it creates a spray, and that spray then is projected, and if it strikes a target, in the case of a target, I mean a surface that it hits, like it might hit the table or the tabletop or a wall. When it strikes that, when you see a sufficient number of small spots, you can determine that it is the result of an energy source consistent with a spattering, such as just clapping your hands if you had a liquid in your hands.
Now, you said that, in your opinion, the stain on the ankle was not a spatter pattern or a spatter.
No, it
Okay.
was very large. It was about an inch by inch and a half, oval.
And in your opinion, sir, what type of stain was that blood stain?
Well, that was a transfer pattern resulting from, I'm quite sure, but not positive, a compression transfer. A lateral or swiping action is the other possibility, but on the dark socks, I could not see any evidence of a feathering out on either side. So I conclude it has to be a compression transfer with no lateral movement sideways or, if any, extremely slight.
Now, when you say a compression movement, would that be consistent with a smear as opposed to a spatter?
Well, a smear generally, I think, is interpreted as having some kind of a lateral motion. Otherwise, it's just a drop or a pool. But it's not as consistent with a smear as it is just having blood on your hand or some object and touching it and pulling it away. For example, a fingerprint made with blood that's identifiable is not a swipe action or a smear, or it would not be identifiable. It is a direct compression and release.
Okay. You mentioned earlier that you and Dr. Lee took some photographs through the microscope that day. Is that correct?
Yes, it is.
Okay. Can I have the this you've already seen this is one of our I believe this will be defendant's 1276.
And what is it, photograph?
It's a photograph, it's a photograph without the aid of a microscope of sock 13A,
Thank you.
showing the ankle stain.
Proceed.